Often overlooked as a key issue in constitutional ratification, debate over the immigration of alien persons and reception of foreigners into the United States held ramifications affecting large portions of the proposed new government. Delegates at Philadelphia ranged from liberal immigration ideals of the Declaration of Independence and American Revolution to bordering on xenophobic regulations of those admitted into the Republic. Debate over foreign entry also encompassed foundational theories and logic behind what it meant to possess American citizenship. Foreign assimilation into American culture also drove the development of a national identity, which in turn led to the consolidation of racial theories and rankings. State or federal supremacy also played a key role in immigration debates within ratification arguments. Would naturalization be held at the state level, or would the new federal government delegate citizenship? The result of debates over citizenship and immigration remained relatively inconclusive. While the framers of the Constitution set out to fix the Articles of Confederation's shortcomings, the Convention left the issues of state or federal sovereignty over naturalization, citizenship, and the immigration of aliens largely undefined and in a state of ambiguity. This uncertainty complicates the viewing of the new republic's immigration policy. Did the country exist on the revolutionary principles of free asylum for all, or was it a selective nation scrutinizing those who desired to enter its borders? The idea of naturalization of an alien within the era did not exist as a novel concept in post-revolution America. Legally defined as the process of granting citizenship onto someone of foreign birth, the 13 colonies regularly practiced naturalization. Since the 17th century, colonial legislatures, councils, and governors naturalized settlers. An oath of allegiance to the colony, substantiated by a time of residence and land ownership, allowed the alien to meet naturalization requirements. Once naturalized, the person obtained enhanced rights as a citizen of the particular locality. These rights often included, but were not limited to, increased land and property rights, suffrage, and the ability to hold high office. Colonial legislatures highly encouraged immigration, and naturalization became seen as a boon to the colonial culture and economy. Citizenship based on colony, along with the monarchical hierarchy, limited Americans developing clear distinctions between themselves and those outside the bonds of colonial citizenry. After the American Revolution, the theme of a broader, proto-national citizenship began to develop. American intellectuals began to consider large-scale, visual variations within society, and exactly what constituted as an American citizen. While European inhabitants of the colonies undoubtedly considered themselves different from their African and Native American neighbors, allegiance and submission to a royal system limited exploration of racial differences. No longer bound by the English crown, America had to decide whom the Revolution's egalitarian themes actually extended to. These debates placed citizenship exclusively in the hands of white Europeans. Blacks, Native Americans, and the darker-skinned Europeans were excluded in talks of citizenship qualifications. In J. Hector's Letters from an American Farmer, the author, examining the newly formed nation, defines what the new term American actually entails. Frequently using monolithic terms like "we are a people" and "united by the bands of mild government," Hector expresses the growing national identity felt by the members of the nation. Further focusing on the existence of one people, Hector identifies Americans as a racially similar mixture of European settlers. Revolutionary and constitutional-era immigration, while lacking the mountains of paperwork present in today's naturalization process, differed from state to state. Under the Articles of Confederation, each state could establish their own code of regulations about the incorporation and assimilation of aliens into the country. During the war, the process for naturalization, at least for English immigrants, proved incredibly relaxed. In the midst of conflict, extra processes and protocols seemed redundant, especially since the immigrant would have already declared his support of the revolutionary cause. Non-English immigrants during the Revolution, while not strenuous, faced a slower route to naturalization due to speculation on how effectively they could assimilate to American customs and government. Each state dealt with the influx of Europeans by setting up guidelines for the introduction of the immigrants into society. Pennsylvania deemed that white foreign settlers could acquire land and property upon an oath of allegiance. Following a year's residence within the state, the alien would be recognized as a denizen. This position held all the rights of a natural-born citizen except the ability to be elected as a representative. That privilege came after another year of residence. In New York, the power of naturalization rested with the state legislature. The immigrant took an oath of allegiance that renounced any former devotion to a foreign prince, ruler, government, or law. Maryland required those seeking naturalization declare their support for the Christian religion, along with an oath of allegiance in front of the governor and his council. In 1779, the Virginia General Assembly passed a law stating that all white persons born in the territory or those that had resided for 2 years were citizens. Any immigrants following the mandate could gain citizenship by proving intention to live within the state by oath or affirmation. Regardless of the many variations of immigration policies across the nation, no type of middle ground existed for aliens living in America. Those who came could not live on a permanent resident status like today. Successful immigration consisted of full assimilation to and the adoption of American virtues, government, and culture. Most states required a renouncement of all other foreign allegiances and oaths. A large majority also stipulated a residence requirement before citizenship could be granted. This waiting period acted as a time for the purging of foreign influences, so the transition between alien and citizen could be seamless. Although a general sense of nationhood and citizenry existed under the Articles of Confederation, no type of broad membership was ever articulated within the document. The lack of an efficient and encompassing path to citizenship caused concern with some and fueled debate about the Article's possible impotence. Immigration and naturalization played a large role in the debate over the U.S. Constitution, with the Articles of Confederation placing the power of naturalization in the hands of the states. One of the key issues arising with immigration centered over state versus federal power. Would the federal government regulate naturalization, or would it continue to be dealt with at the state level? Federalist paper authors Alexander Hamilton and James Madison bring naturalization to issue in their defense of the Constitution. In Federalist number 32, Hamilton establishes that Congress should have the power to regulate and introduce uniformity into the immigration process. With little to no uniformity in naturalization at the state level, varying protocols for immigration bog down and hinder the efficiency of government. This in itself, according to Hamilton, should place naturalization in the category of express powers held by the federal government. Madison, in Federalist number 42, takes the defense of federal control of naturalization one step further. Examining the Congress's dealings with foreign matters, Madison groups naturalization with the legislature's duties of defining foreign treaties, receiving ambassadors, and importing slaves. Madison makes it perfectly clear that any interaction with a foreign entity, whether on a national or citizen level, should fall under congressional power. Having made this point, Madison lays out the deficiencies of the Article's naturalization clause. In the fourth Article of the Confederation, language discrepancies leave naturalized citizens' rights hazy at best. Within the clause, 3 different words, inhabitants, free citizens, and people, are used to identify aliens pursuing naturalization. Furthermore, with naturalization held by the states, one state can effectively render another state's naturalization rules null and void. A person guilty of a crime prohibiting them from gaining citizenship in a particular state can simply move to a different state where their charges are invalid. At the ratification debate in Philadelphia, a large number of delegates agreed that the nation needed a uniform process of naturalization. Edmund Randolph, proposer of the Virginia Plan, and William Patterson, designer of the New Jersey Plan, both included stipulations that allowed Congress to deal with contradictory state naturalization laws. The two main plans, however, diverged when discussing whether states were completely unable to naturalize, or if only a few uniform regulatory clauses were needed. Further controversy arose when discussing the amount and quality of rights granted to naturalized citizens. Stemming from a fear of foreign influence and infiltration, the once lax regulations were now seen as a danger to the fragile nation. In order to curb this fear, George Mason moved that the qualifications for members of the House of Representatives be increased to 7 years of residency rather than the proposed 3. Regulations for holding a Senate seat were also put under scrutiny. Charles Pinckney moved that due to the increased power and influence of the Senate, the residency requirement should be upped from 4 to 14 years. With the Senate responsible for foreign treaties and affairs, Pinckney said that there was, quote, a peculiar danger and impropriety in opening its doors to those who had foreign attachments, end quote. Taking Pinckney's argument to the next level, George Mason stated he too worried about naturalized citizens in the Senate, and if not for the valor of immigrants in the Revolution, would propose limiting the upper chamber to native-born citizens only. Other delegates opposed the raising of requirements for high offices. Oliver Ellsworth thought it would hinder profitable aliens from immigrating to the country. The Scottish-born James Wilson said that from personal opinion and experience, the thought of the amendment invoked feelings of discrimination and degradation. Madison, in opposition to the raising of qualifications, invoked the Constitution's proposed power of Congress to uniformly regulate naturalization. With the power to impose uniform codes, Congress could make different periods of residence that denoted different rights of civic participation. Madison also thought that the raising of Senate requirements would add a tinge of illiberality to the Constitution, which would in turn deter beneficial aliens from immigrating. Gouverneur Morris, in favor of upping the senatorial and House requirement, proposed that the limitation should not affect any persons who were currently citizens, and in effect, those that were citizens at the time of ratification would be grandfathered in. John Mercer seconded this point, saying that this would prevent any angering of immigrants that had become citizens with the faith that they would be granted full rights. Roger Sherman opposed this amendment, saying that the convention was under no circumstances obliged to meet the expectations of recently naturalized immigrants, because it was not the United States that promised them full rights, but the individual states to which they pledged. Pinckney seconded the motion, saying that it would be cumbersome to the convention to be bound by ineffective previous obligations made by the states. The debate then moved into a discussion of whether or not naturalized citizens were to be on the same footing as natural-born persons. The committee also ruled that naturalized citizens should not be barred from holding the presidency. This was eventually abridged to state that only naturalized citizens at the time of the Constitution's ratification could hold the office of the president. So in actuality, only those naturalized before ratification stood on equal footing with natural-born citizens. While almost all of the delegates agreed that citizenship existed as a prerequisite for holding high office, the ratifiers offered little to no discussion concerning the relationship between state and national citizenship. The Constitution, much like the Articles of Confederation, exhibited a comity clause, saying, quote, "The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states," end quote. Did the congressional power to institute a uniform rule for naturalization actually create a national citizenry, or did it simply establish a standard for state membership?